A newsletter subscriber asked me a question today. The question was, does the government have to let you know if their parent is the subject of a guardianship? So there were some uncertainties, and I replied. We had a back and forth exchange by email, but my initial thoughts were, yes, the government does have to let you know, but there's even a fallacy in that question. Typically, the government is not the one that's filing for a guardianship petition. It's an interested person, so a spouse, an adult child, a hospital, a nursing home, a facility. Someone's filing for this petition for guardianship, and then interested persons have to be made aware of it, meaning someone related to the case, right? The spouse, family, everyone that I mentioned that could possibly file has to be notified. And once a hearing starts, and if a guardianship is obtained, well, the court will appoint a guardian, whether that be the initial petitioner, if possible, or it could be a family member or someone that steps up to the plate that the court approves of, and or they could appoint someone from a court-appointed list. But in the event that the court does find that a guardian is required and does appoint a guardian, all of the same persons that had been previously notified have to be notified again. So there's a little back and forth, and there's some uncertainty even as to what happens. Sometimes children aren't really around, or they're a little bit estranged, or they live in another state, and they can get caught off guard if the condition of a parent deteriorated quickly, and then someone alerted someone, right? So a neighbor could alert the police, a person could faint or collapse and be brought to a hospital, and then the hospital files something. So there's many different versions of what could happen or transpire, but notification is required throughout the process.